Hello and welcome to Topic 8, Lecture 2. And in this lecture, we are going to be learning about warrantless searches. Now, in the previous lecture, we ended by saying that obviously getting a warrant to search is preferred, but it's not always practical. That it takes time to get a warrant because if for no other matter, you need to go to a judge to go and get it. And so that there are times that the Supreme Court has found that it's reasonable to waive the requirement for a warrant. And in fact, as we talked about the Fourth Amendment, that the reasonable clause and the warrant clause, they're not like necessarily connected to each other, because what makes a search allowable by the government is if that search is reasonable. And so, as I had mentioned in the previous lecture, Chief Justice Roberts, stated that reasonableness is the touchstone of the Fourth Amendment. And so a search without a warrant is what's known as a warrantless search. And these can be legal if within the scope of the exceptions that are outlined by the Supreme Court. So it's the Supreme Court that determines whether or not a search is reasonable, and whether or not a search that is reasonable and does not have a warrant is in fact allowable, is in fact constitutional. So in this lecture, we're going to take a look at what the Supreme Court has said are legal warrantless searches, or the exceptions that the Supreme Court has identified to the warrant requirement. Your textbook talks about several exceptions to the warrant requirement. They talk about exigent circumstances, search incident to lawful arrest, stop and frisk, consent searches, automobile searches, and in plain view searches. In this lecture, we're going to look at the first four, but I'll leave it to you to read in the textbook about automobile searches and in plain view searches. And so while we are learning about each of these exceptions to the warrant requirement searches, I want you to ask yourself, like, what is the reason for the warrant exception? Keep in mind, like, okay, if there is a exception to the need for a warrant, how big can the search be? What is there a limitation, or what is the scope of the search? And then finally, of these that you're learning about, including the automobile search and the plain view, are any of these, do you think that they shouldn't be legal searches? Because right now these are all legal searches. Do you disagree with the Supreme Court? Are some of these warrantless searches that you do not think should be constitutional? All right, let's go ahead and look at those first four. So the first exception to the need for a warrant is when police are confronted with exigent circumstances. And so no warrant is needed if the circumstances require immediate or urgent action. And that's what exigent means. It's like something that's happening that's pressing and that you need to immediately respond to it. And so examples of exigent circumstances are hot pursuit, threats to evidence, danger of escape, threats to other. Okay. So for example, with hot pursuit, if law enforcement see some crime being committed, let's say people shooting each other on the street, and then they run into a home, okay, well, normally you would need a warrant to enter the home, but this is in hot pursuit. They saw the crime taking place, there's probable cause, and going into a home, shooters could definitely present a danger to others. So I'll let you read about these different examples in the textbook, but whenever police are faced with these sort of emergency circumstances, they don't need a warrant. And the reason for that is that lives are in danger and evidence can be in danger, right? So if there's probable cause that somebody has drugs and they're going into their home to dispose of that evidence, right? That's an emergency situation, at least, as the courts have seen it. And if there's an individual who's keeping people hostages in a home, obviously that's a threat to others. And so that, you really cannot get a warrant, because if you did, people's lives would be in danger. The scope of an exigent circumstance search is, well, you do have to have probable cause, okay? And so, if you think somebody is, they use the example in the textbook that somebody's selling drugs and then they go into their house and you follow them in there as a law enforcement because you think they're going to, destroy the evidence. Well, you better be damn sure that there was actually, a drug deal going on, or that this person is actually, a drug dealer, that you have to, it's reasonably based on the evidence that that person is, short of probable cause, that you cannot, engage in this kind of warrantless search. It also must be a true emergency, okay? And that, however, if it is a true emergency, it's really limited if that emergency exists. And so I was reading about the Boston Marathon. You guys might not remember this, but several years back there was a terrorist attack in Boston at the Boston Marathon, and following that, they couldn't find who the terrorists were who did this horrific attack. And basically, law enforcement were going house to house searching with no warrants because it really was this exigent circumstance. They were trying to find these very dangerous people, and it was quite limitless because as that emergency was going on. Another exception to the need for a warrant is incident to a lawful arrest. Okay, and so a person can police can search a person and the immediate area around the person after a lawful arrest without a warrant, and that comes from the case Schimmel versus California. And this search incident to arrest is often called like the Schimmel doctrine. The search must take place immediately following arrest. So once that person is under arrest, then you can search that immediate area. But the searching area is only an area in immediate control. Okay. So let's say that, law enforcement are in hot pursuit and that they are pursuing an individual into a home because that they were involved in a crime. And then at that point, they arrest that individual inside the home. Well, law enforcement have every right to search that area around them, their backpack, any area that is within a grabbing area. Okay. And the reason for that is because of wanting to make sure that law enforcement is safe. Okay. And so there's no need for a warrant for that. Now, do keep in mind, if the arrest itself is illegal, if it's an invalid arrest, then the search is invalid as well. So even if contraband is found during that search incident to arrest, it's null and void because the arrest itself should have never taken place. It's allowed without a warrant for officer safety reasons, and so you want to make sure that when somebody is arrested, that you are able to search them, search the immediate area, search their backpack, because you don't, without a warrant, because you don't want officers to be in harm's way. And the scope of it could be a full body search, the backpack that is on the body, and anything that's within the grabbing area of the person who is arrested. Anything beyond the grabbing area would be out of bounds. Okay. And so law enforcement have to be mindful of making sure that their search is limited to that immediate area. So if somebody consents to a search, there is no need for a warrant. And so if police ask, can they search you? And you say yes. Can they search your house? Can they search your car? And you say yes. Then you've basically waived your Fourth Amendment rights. And so that's why this kind of search is allowed without a warrant, because even though you have the right to be free from unreasonable search and seizure, you can waive that right. And so if you consent, then cops can search. Now, there's very specific scopes to the consent search. And so for one, the search is limited as far as the consent leads. And so if police say, can I search your backpack? And you say sure, and you let them search your backpack, and then they say, can I search the trunk of your car? And you say no, the search stops there. And just because you give consent to have your backpack searched doesn't mean you've given consent to your person being searched or other things that are around you. So the scope of a consent search is as far as the consent leads. Most importantly, the consent must be voluntary and intelligently given. And so you'll read in your textbook about cases where, individuals are sort of pressured or almost coerced by law enforcement to consent to a search. Well, if that's the case, it's not a consent search because you can't consent to something under coercion. Also, you cannot be drunk and consent to it. And so it must be intelligently given, either not under the influence and also, making sure that somebody is mentally aware enough in order to provide that kind of consent. Obviously, a child consenting to a search would not be a consent search because, children, minors are limited in terms of their ability to give consent. You'll read in the textbook about limited third-party consent. And so, in other words, roommates. And so what if you live with roommates and the police show up and, the roommate says, go ahead and search. You can search our apartment. Well, there are limits to that. That when police search, they could, and a roommate says, go ahead and search, the police could search the common areas, and they could search the bedroom or the private area of the person who gave that consent. But if the other bedrooms where the other tenants live, that the police would have to be limited. They could not, conduct searches of those private bedrooms because those people were not there to give consent. And if there's two tenants there and one says search and the other one says don't search, you can't search, okay? And so you could read about that in the textbook. Now, a lot of people feel like they have to consent because if you don't consent to a search, if you don't consent when police ask you to, can they search you, that constitutes probable cause, and then they can engage in a search. That is not true. If you refuse to consent, this does not constitute probable cause. And so if no probable cause exists, no search can take place without your consent. And however, that when law enforcement pull you over or whatever and say, can I search your vehicle? They wouldn't be able to do it because they don't have probable cause, right? And they just keep asking you over and over again. Cops don't need to tell you, you're free to go at this point, but can I search your vehicle? They can just sort of ask and ask and ask about searching the vehicle. And so in that way, it sort of tips the balances to law enforcement because then they can kind of potentially badger someone into giving that consent, although obviously coercion and being forced into it is not allowable. The last search that we're going to talk about is what's known as a Terry's search or a stop and frisk search. This is a very controversial type of search. In fact, some municipalities are outlawing these kinds of searches. However, in the case Terry versus Ohio in 1968, the Supreme Court said that these kinds of stop and frisk searches are constitutional and do not violate the Fourth Amendment. So no warrant is needed by police to stop and search people in suspicious circumstances. And so, let's say cops are driving around and it's 2 a.m. and there are people hanging outside of a convenient mart looking kind of suspicious, right? Then police can go over there, stop those individuals, and potentially frisk them without a warrant. Not only that, but there's a lower threshold that's needed. You don't need probable cause that these people hanging outside the convenience store that there's evidence to suggest that a crime is going to be committed. It's reasonable to think a crime is going to be committed. It's just reasonable suspicion, and that's a much lower threshold, right? And so really just hanging out in a low-income area at 2 a.m. Constitutes reasonable suspicion. And that's why you can sort of see why these are controversial searches. Now, the stop and the search are separate acts. So the search still must be reasonable. So, for example, when you, let's say that you've got 3 people standing outside the convenience store at 2 a.m., cops come over and they say, well, what are you doing here? And they say, well, we work here, we're on a cigarette break, and this guy's a security guard protecting this place. Well, at that point, the stop got answered, and there's no reason, it's not reasonable to engage in a search. However, if you stop these people and they're like, I don't know what we're doing, and they seem really nervous, look like they're trying to get away, well, then that would be reasonable to then engage in a pat down. It's allowed without a warrant, again, because of officer safety, but also because it is seen as a crime-fighting technique, right? During the 80s and 90s, when crime was really high, then we, sort of saw a proliferation of the stop and frisk. So it basically sort of really reduces the rights of individuals who live in high crime areas, because just living in a high crime area means that you are, for the most part, subject to these kinds of searches, invasive searches, in the name of fighting crime. The scope of a stop and frisk search is a pat down of the outer garments, okay? So if you stop and there's no good reason for why folks are hanging outside the convenient mark, they seem really nervous, then at that point you can pat down the outer garments, because the idea is you're patting down to see whether or not they have weapons. Okay, so just to review, here we have all on the different types of exceptions to the warrant requirement and things you should keep in mind as you're learning about them. What's the reason for the exception, scope of the search, and are any of these illegal searches that you think should not be legal? Okay, thanks for listening. I appreciate your time and attention, and I'll talk to you again soon.